The accused number 4 in the Senzo Meyiwa murder trial, Mthokoziseni Maphisa, will know on Tuesday whether or not Judge Ratha Mokgoatlheng will return a verdict of not guilty without him having to present his defense after the state closed its case. Maphisa is the only one of the 5 men standing trial in the High Court in Pretoria who has pursued an application for a discharge at the close of the state's case in terms of Section 174 of the Criminal Procedure Act. He continues to profess his innocence, and his lawyer, Advocate Zithulele Nxumalo, argued vociferously in support of the application, saying no direct or indirect evidence has linked his client to the commission of the crime. However, the state argued that they have solid evidence against all the accused, in fact. So let's discuss this matter then and take it further. I'm joined in studio by legal analyst Elton Hart, a practicing attorney. Good afternoon. Thank you for coming through, Elton.
Afternoon to the viewers.
Section 174, discharge at the close of the state's case. What are we talking about, and why do you believe it is that Maphisa, of all the 5 accused, is the one pursuing this angle?
If one looks at Section 174 of the Criminal Procedure Act, one needs to now understand this section of the Act very nicely. It doesn't say there's no evidence at all. It makes the distinction between sufficient and insufficient evidence. And Maphisa is saying that there's insufficient evidence that link him to the commission of the crime. Although there is this Zungu chap that said he saw them in Vosloorus on the night, to be in Vosloorus doesn't necessarily mean that he was involved in the crime, in the commission of the crime. But then again, that is now circumstantial evidence that the state has to build its case surrounding that to say cell phone data, the communication between the accused persons, and you try and create that type of link. But when he brings that application, he's not saying there's no evidence that say he was not in Vosloorus at that time when the crime was committed. He's maybe say sufficient evidence to link him that he played a role, direct or indirect, in the commission of the crime, because we heard they were talking about co-conspiracies and those type of things in the arguments.
So what did he need to do to convince Judge Ratha Mokgoatlheng that I shouldn't even have to respond to what the state has presented, find me guilty at this point after the state closed its case? What was the bar that he needed to meet?
Obviously, remember, an accused person has no onus on him whatsoever to prove that he's innocent. The state has to prove beyond reasonable doubt that he was involved in the commission of the crime. But when we get to the 174 point, the state needs to just say that there's prima facie evidence that suggests that accused number 4 was involved in the commission of the crime. And he has to now come and sort of say, but that suggestion by your evidence, that's not the only inference that can be drawn from that evidence. There is many other inferences that can be drawn. And once the court can draw different inferences from the same set of evidence, then it means different interpretations can apply to that evidence. Then you give the benefit to the accused person. And he just needed to sort of have, not say beyond reasonable doubt, this evidence can't stand against me, to just say that there's different inferences that can be drawn why I was in Vosloorus at that stage during that time. Not you can find me at the Khumalo house around that vicinity, looking at the cell phone triangulation and data pinging. Was I at that Khumalo house? And we tried to see, but I think they somehow, when they dealt with the analyst, when they dealt with the cell phone data, they did not do enough for me to actually say that there is other ways that you can also interpret this data.
So say a bit more then about that, because as part of that, trying to prove that there's no evidence that the state has led upon which a reasonable person could convict the accused. They've had to now almost help all of us in revisiting some of the evidence that has been led over a long period of time. So they talked about DNA, they talked about ballistics, and you mentioned cell phone footage. Just talk to me about the usefulness of undertaking that exercise.
No, obviously, if you go, say, for instance, the DNA, because they look at that cap that was lying at the scene, that they said one of the intruders had the cap on.
That had the sweat or something.
The sweat. So they matched it against all 5 accused persons, and that was inconclusive. I'm not saying that there was not markers on that DNA. That doesn't suggest it could be from one of the 5 accused, but it was inconclusive. Then I said, that's why I said when I look at the cell phone data, the pinging and the cell phone triangulation, they could say most probably that these guys were in a certain triangular.
Yeah.
But that triangle is so wide. They could have been at some other place. And I could remember that from the evidence that was, in cross-examination, when Advocate Ngome Zulu was still alive, they put to say, but these guys were not really at the hostel. They were at some other place, but in close proximity of that. So what Zungu was saying, it couldn't be that they were all together at the hostel and what Zungu was seeing, according to him. So you could have worked a little bit more with that. And then when we talk about the ballistics, one needs to check. Okay, obviously these guys were caught way, like I think in 2020 they were arrested. So it's 6 years. You would not find a lot of ballistics evidence pertaining to gun residue on their end. So that would be gone. So you need to work with the gun that was found. And for me, I think when, I think it was Mangena that did that testimony pertaining to the ballistics, I think they should have digged a little bit deeper in how they say the bullet trajectories worked, and also that thing. And even for me, I would have said they had to look at a gun. Can you dismantle a gun and take the what is this now? This I don't have the proper...
the chamber or something.
The chamber, there's the word. You're helping me now nicely. The chamber of that, and can place it on another gun and shoot through, and you can you do those type of things? Just, you need to create doubt in what the state is presenting, then the judge has got something to work with.
But a big hurdle, though, Elton.
No, a big hurdle.
A big hurdle was the confession of accused number 2. And much of the state's response said, this man confessed and twice confessed. In both confessions implicated you, accused number 4, which we've now taken together with other circumstantial evidence. You may be right about the DNA, you may be right about this and that, but taken with other evidence, it gives you a bit of a headache.
But for me, and this is my view, I think on the confessions, now looking at hindsight of all the evidence that was laid, you can see that, I don't know, I can't recall who was, I think it was Gininda who was the head of transporting these guys up and down. And they, at some stage, at the beginning saying, no, these vehicles were not there, these vehicles were not there. And later they conceded, but these vehicles is there. And that's after the court has made that ruling pertaining to the confessions. So then you need to put one and one together. Before that you said these vehicles were not there. Now you're saying that something is not adding up. And then does it mean that was these confessions rightfully admitted? And that is for me the prickly pear. And what I think people, because the trial is running so long, they forgot about what Gininda said at the beginning and said later to concede certain vehicles was now suddenly
And
there.
importantly, Elton, please talk to this point very quickly. The confession of one accused not being used against other accused as well, They're relevant to you. You are admitting your role in it. You may implicate others, but...
You can most probably make a confession and say what happened, but obviously co-accused, they can never testify against each other. They can never testify, because then you need to now say, am I not testifying to get a better deal out of the state from the other? And for me, that's the playing ground. And I think maybe if they work better with that confessions to actually revisit that issue. But I think, and this will remain my opinion, I think those confessions were never supposed to be allowed to get in.
All right, let's leave it there. Thank you for coming through. Let's see what happens when the decision of Judge Ratha Mokgoatlheng comes through on Tuesday on that application for a discharge at the close of the state's case.